Anyone paying attention to Walker County schools lately has surely noticed that district leadership is bereft of both transparency and accountability. But why? To answer that question, we must look back in time to the spring of 2018, a pivotal year when an incumbent member of the Walker County School Board, Mike Carruth, sought re-election. Unopposed, Carruth sailed to victory in the spring primary, effectively securing his seat. The Carruth family, it appears, has a deep-seated commitment to education. By this same spring, Mike's son, Justin Carruth, had emerged as a teacher in Walker County, and later that summer he ascended to the role of an assistant principal. This elevation to power, however, is where the questions and problems begin. The state law of Georgia offers explicit guidance on this matter. The law declares that no one with an immediate family member sitting on a local board of education or serving as the local school superintendent, or as a principal, assistant principal, or in a system administrative staff position in the local school system can serve as a member of the same board of education. Justin Carruth's appointment as assistant principal in 2018 should have signaled the end of Mike Carruth's tenure on the board. The law, however, includes a clause which could add confusion. It states that it only applies to members elected or appointed on or after July 1, 2009. So, was Mike Carruth grandfathered in and not subject to the law? No. A clarifying statement by Russ Willard from the State Attorney General's office when the law was enacted in 2010 disputes this. The law allowed for current school board members in 2010 with family and administrative roles to complete their term, but forbids their subsequent re-election. As examples, many local board members across the state were unable to run for re-election. In 2017, in Polk County, a board member resigned when their family received a promotion to assistant principal. A mirror situation to that of Walker County, and yet, in Walker County, Mike Carruth remained on the board in violation of the state law. Now let us fast forward to the fall of 2022. Mike Carruth continues to serve and wins re-election once more. Justin Carruth's career trajectory points ever upward, landing him another promotion, this time in the central office as CTAE director. State employment records list him as vocational director. At this point, a fair question is whether his father may now be eligible for service on the board since Justin is no longer an assistant principal. Unfortunately, no. The law is clear. Justin's new position falls under the category of system administrative staff. An official guidance document from the Georgia Department of Education states that system administrative staff are certificate employees assigned to non-instructional duties. The CTAE or vocational director role fits squarely within this definition. And yet again, Mike Carruth remains, despite the law. But he's not alone now. Karen Hardin, a board member appointed at the beginning of 2022, won an election later that year. Her son, Scott Hardin, has been the technology director since 2017, a role also classified as system administrative staff. This places her in a parallel predicament. Yet, these two board members persist in serving despite the law being plain and clear. If you are asking yourself why, you are not alone. When asked last year, the superintendent, Damon Raines, stated that the district had previously sought advice on the matter from the State Attorney General's office and the Georgia Department of Education. Both allegedly agreed that the roles occupied by Justin Carruth and Scott Hardin were mid-level management roles and not system administrative staff. How convenient and wrong. Attempts to obtain these opinions through open records requests, however, were met with a wall of silence from both the Department of Education and from the State Attorney General. When an open records request was made to Superintendent Raines to obtain records of the alleged opinions, Raines shielded the alleged records under attorney-client privilege. The opinions, even if they exist, are still incorrect, and they directly contradict official guidance as well as plain common sense. However, it may be that through these opinions, Carruth and Hardin were ill-advised, and that is why they continued to serve. Neither circumstance alters the fact that they are still serving unlawfully, but it might explain their reluctance to resign. Now, where are the elusive opinions? Why are they concealed? parents and citizens should reach out to their board members and the superintendent. Demand that proof of the opinions, if they exist, be made public, if only to clear up whether poor advice offers some explanation. Despite everything, what remains unambiguous is this: 2 board members are serving in clear violation of state law. This has real consequences for the district and for students. With the board unwilling to do anything and throughout all the confusion and chaos swirling around the district, and with the start of a new school year, the superintendent continues to escape scrutiny. He continues to escape accountability. Accountability for concealing lead contamination in school water supplies, and accountability for not telling parents, teachers, board members, or even the water company about any of it for months. And now there is the added bonus that school property taxes are set to rise once more. Change is possible, but only if parents and citizens step up and demand accountability. You now know the truth about the board. Use it. The 2 board members should resign, but they can be removed through the courts. Either citizens and parents step up for change, or we accept the status quo forever.